Hey, John.
Laura, I can hear you now.
Can you just hear me now?
Yes, you blinked out for just a second.
Okay, thanks. So I just got a message that it's just now being recorded. Has nobody been able to hear anything I've been saying for the past 5 minutes?
I've been able to hear you.
No, I think everyone's been able to hear, so it's just that it hadn't been on record. So
Gotcha. Okay, I don't want to repeat all that if everybody's heard it. Okay, sorry for the interruption. So Jeff has been a staff attorney with Jacksonville Area Legal Aid from 2004 to 2017. He has specialized in tenant and landlord housing issues, providing civil legal services to low-income clients who cannot afford to retain private counsel. He's represented individuals, families, and groups of clients such as tenant associations. Jeff has now started his own practice in January of this year in order to expand into new areas of law. And he's handling business litigation, business contracts, transactions, and consumer protection. And our final speaker will be Evan Rosen. Evan has his own practice in Fort Lauderdale, Florida, where he owns his own firm and represents clients in foreclosure defense, debt defense, and consumer collection violations. And he's been doing that for about 10 years in Fort Lauderdale. And so we're very thankful to have him as well. So we're going to go ahead and get started with Karen, who's going to talk to us a little bit about the FEMA application process. Karen?
Thanks, Laura. All right. Today I'm going to talk to you about FEMA and the different benefits that are available, as well as the process for filing a claim with FEMA. I have the privilege of working under a grant that's provided by the Florida Bar Foundation through Three Rivers Legal Services. The information that I'm going to provide you with today is not going to be a comprehensive review. Can everyone see my screen and hear me?
Yes, Karen, we can see it. We can hear you.
Oh, great. Okay. So there's been this natural disaster in our area. What are the next steps that we should take? Well, first of all, as a threshold matter, we should know that FEMA is the Federal Emergency Management Agency, and it's set up as an umbrella agency that coordinates both state and federal benefits for disaster victims. So FEMA has codified the declaration process at 44 CFR Section 206, Subpart B. All emergency and major disaster declarations are made solely at the discretion of our president. Section 401 of the Stafford Act actually requires that a request for a declaration come from the governor of the impacted state. This is important because those federal benefits don't come to each state until that declaration is made and approved. So the request is going to actually be made through a local or regional FEMA office. In some cases, there is a preliminary damage assessment to figure out the extent of the disaster and its impact on individuals and public facilities in that community. So this information is included in the governor's request to show that there is a need for those federal dollars. In cases like Hurricane Irma in the state of Florida, which impacted those that live in Florida in September of 2017, the assessment didn't even need to be completed prior to the submission of the governor's request because it was an obvious catastrophic event. Based on the governor's request, the president can declare the disaster is present or that the emergency exists, and this activates an array of different federal programs to assist in individuals' recovery efforts. So individuals have a situation in which there are different benefits that are available. My goodness, I apologize, you guys. The slide is is taking a second. Let me get us back up. Here we go. So there are different benefits that are available. Not all benefits are available in each storm that occurs. Basically, there are individuals that are going to be eligible for assistance, but again, not everyone is available. So first of all, we've got this wonderful declaration so that we know that there are going to be benefits. Individuals who are eligible, not everyone in the household has to be eligible. It can just be one person. A member of your household would have to be a U.S. citizen, a non-citizen national, or a qualified alien. Additionally, to qualify for these benefits, the home that you live in has to be where you live the majority of the year. So if you're fortunate enough to have multiple homes, it would need to be your primary residence for you to be eligible for those benefits. And the standard that FEMA is looking at to determine whether or not it's going to award assistance is whether or not the home is safe to occupy, or whether or not it's habitable, or the key is the key terminology that FEMA uses in making its determination whether or not to award benefit. Additionally, when FEMA does its evaluation, it has to determine that there are necessary expenses or serious needs that have resulted from this disaster that's occurred. So those are the individuals that are going to be eligible for assistance. Now, what type of benefits are available? Now, today I'm not going to be able to go through each and every benefit that's out there, but there are two that I want to focus on today because these are the ones that are most prominent when a disaster does occur. So first of all, housing assistance. Some good news. This assistance is available to not only individuals that own their property, but also renters in different areas. So it's possible that many of you may have been hearing on the news recently terminology TSA, or temporary shelter assistance. In Puerto Rico, there was a request that the temporary shelter assistance time period be extended for individuals. That assistance is provided to both renters and individuals that own a home. And what FEMA does is it allows individuals to stay in a hotel while the landlord or the homeowner is making repairs. During Hurricane Irma, individuals from September 10th all the way up until March 10th had that ability to stay in this TSA housing. So FEMA will provide this temporary shelter assistance. It will also help individuals that are renting. Let's say they're not able to get back into their property because the landlord's not going to be able to make the repairs. They have to move somewhere else. FEMA will issue a payment for the deposit plus 1 month of rent to those individuals. It also makes payments to individuals that own homes for home repair and even in some cases home replacement. So those are some, yes.
I'm sorry to interrupt. I don't think that the slides are showing the current slide that you're on. So
okay.
The first slide that you put up, and so I just wanted to check and make sure that you had.
Do you see a slide that says what assistance does FEMA provide to individuals? Is that up?
No. So we're seeing there's been a natural disaster in your area. Now what happens?
All right. Technology is not always our friend, I see. Okay.
I don't know if taking it off and putting it back up again might.
Yeah, we'll try that. Sorry, everyone. It's all that's showing on my screen. All right, how about now?
Not sure. But that's okay. I don't want to interrupt. I mean, certainly it's valuable information, even if the slides aren't.
Okay. Any luck? Anything better right now?
Nope.
Oh, my goodness. Okay. Well, I'm going to keep going, and I apologize, everyone. I'm certainly happy to share the slides at a later time. The other form of assistance that's available is the other needs assistance. Now, this is a larger category of different types of assistance that's available to individuals. So not only are homes impacted, also the belongings within the home. So personal property, assistance to repair or replace common household items, including things like appliances, equipment that supports daily activities is one thing that would be available. Medical or dental assistance. I've had clients, regretfully, that have had damage to glasses, dentures, and they've been able to recover benefits under this other needs assistance. Funerals. People regretfully have died in some of these disasters, and FEMA has stepped in and provided disaster funeral expenses, including the cost of a casket or other funeral services. Also, some miscellaneous expenses, transportation, assistance to repair or replace a vehicle. I've had individuals that their cars have been flooded, and that's something that many of you may have seen on the television, cars completely underwater. One thing in the state of Florida, it's a law that you have liability coverage. I've had two different clients in which we've had to file FEMA appeals when there has been an issue with transportation. One client maintained the liability coverage, so there was the no comprehensive coverage for the storm, but because they had that liability coverage, FEMA was willing to pay for the damages. The other person had a car that wasn't insured, so FEMA wasn't able to step in and help. FEMA also will help with moving and storage expenses. So I continue to move the slides forward, even though you guys can't see them. So the next thing is, okay, here are some benefits that are available, but what's the actual process for filing a claim with FEMA? How easy is that for individuals in our community? Because the individuals that need help are many times the low income, not the highest educated individuals in our community. There's many different options that are available online, and many of you are thinking immediately, well, why in the world would they have you file online? There's no power if there's been a huge disaster. It's one of many options. So you can go online to disasterassistance.gov to complete an application. There's also a FEMA app on your phone that you can download and complete the application there. They have a 1-800 number, 1-800-621-FEMA that you can call. I've completed the application with clients over the phone, and it takes approximately 10 minutes to go through the different questions that FEMA has. Additionally, right after a storm, FEMA representatives are on site, and they stay on site for a given time period. If you don't know where one of the disaster recovery centers are located, it's very easy. You can send a text for FEMA with your zip code, and it shows you immediately where the different centers are in closest proximity to your home. So FEMA is really trying to reach people in different ways so that they can get help. They can find out if there are benefits available. So you complete the application, whether in person or using technology. The next step is for FEMA to send an inspector to your home. And regretfully, whenever there is a disaster that occurs in different areas, some individuals think it's an opportunity. And so if you have the opportunity to interact with your clients right after a storm and before the inspector comes out, one thing they should know is that anytime a FEMA inspector comes to their home, they're going to call them first and set up an appointment. They're going to have credentials such as a badge with them to show that they really do have authority to act on behalf of FEMA. FEMA hires independent contracting groups to do the inspections. So it depends on who you get, the level of expertise when they come to your client's home. Some individuals have worked with, for example, Vanguard's one of the company for Vanguard for years, whereas others are new and are coming in to try to help right after the storm. So these individuals will come to the home, and many clients tell me the inspector was very nice, but they wouldn't get up on my roof. They wouldn't actually get in the crawl space of my home and look at where the damages are located. And I tell individuals that regretfully, FEMA doesn't have to get onto your roof or get into a crawl space. That's their procedure. It's going to be critical as the homeowner or the renter when FEMA comes to the home to know where those damages are located. So let's say there is an opening in the roof. Of course, that roof opening may have created a leak, and so you can show the inspector, look, there's water damage on the ceiling. Or some of your clients may be brave and get up on the roof and take pictures. FEMA wants that information. You can share those photographs, videos with the FEMA inspector. Your client should know the FEMA inspector cannot make promises as to what benefits will be available. They're going to come go through the application questions with them to ensure that they're accurate, some of them. And that's the extent of what they're able to do, just to do the inspection and to provide the results to the FEMA center that's making the determination as to whether or not there are benefits. So what are the next steps after the claim is filed? Well, what's going to end up happening is there's going to be a payment issued, hopefully, right? So if that payment is issued, that's fantastic. Keep in mind that that's limited to an annually adjusted amount based on the Consumer Price Index. It was just updated in October of last year. For Hurricane Irma, the maximum benefits that were recovered was a total of $33,300. What happens, though, if a payment's not issued? What avenues do you have to help your client? In that situation, if there's a denial of benefits, there's a 60-day time period in which to file an appeal. I've got to tell you that most clients that I interact with do not actually file their appeal within 60 days. And we've been able to come back and to say to FEMA, this is the missing information, or this is why FEMA's determination that their benefits weren't available is incorrect, and we've still prevailed. FEMA does want to have a conversation with individuals. Before working at Three Rivers years ago, I used to do plaintiff's work. I would sue insurance companies for not paying out in first-party cases in disasters like this. And it's a very different relationship with an insurance company on the other side of a case than FEMA on the other side of a client. Insurance companies are bound by the terms of an insurance contract, and FEMA definitely has its own guidelines for when it can issue payment. But with FEMA, you can supplement. You can call and speak to representatives, and I truly get an impression that FEMA is trying anything it can do to help individuals that have been impacted. So in many cases, I'm on the phone with FEMA at least once a week, but it's a back and forth exchange of information. Many of my clients just have difficulty understanding the rules that apply. Many times, FEMA will say, you don't get benefits because you don't own the home. And they're like, of course I own the home. I've lived here 10 years. And so there's some confusion as to the simple steps to actually get coverage. And so getting involved, helping them provide a clear representation of why FEMA's determination was incorrect, providing that supplemental information is going to be critical for FEMA to be able to come back and actually make those payments. I want to mention two other things before I turn it over to Jeff to talk about landlord-tenant situations, and that is, what if you did have insurance? Does that mean that you can't ever recover from FEMA? Many of my clients get confused by this because they have force-placed insurance. So the mortgage company has bought a policy for them, and they say, well, I filed with FEMA. I have this force-placed policy. The insurance company is only going to pay me this amount. There's no way that's enough to repair my home. And there's a relationship between that insurance claim and that ultimate payment that's going to be made, hopefully by FEMA. What FEMA asks is that you pursue that avenue with the insurance company. You get a determination of coverage. Maybe there's none. Maybe the insurance company says, this was flood damage. This is not wind damage at all. So we're not going to pay under your wind policy for flood damages. And then the person can come back to FEMA and say, okay, I got a denial. And then FEMA says, yes, we will step in now and provide assistance. But it's knowing to come back to FEMA and to supplement that claim to get benefits. The next thing is the Small Business Administration. Many of you are immediately thinking Small Business Administration. I thought she was talking about individuals. Well, the Small Business Administration does provide assistance to business owners, But in this case, when we have a disaster like this, it also provides assistance to individuals. It will provide very low interest rate loans to individuals to complete repairs to their homes. And so the great news is that's available. The bad news is sometimes individuals will apply and they don't qualify. FEMA refers them to SBA to attempt to get a loan. And the reason for that is they want to see if they're going to be able to be eligible for that. If the Small Business Administration says, no, we're not going to issue a loan, there's no way based on your financial information that you've shared that you would be able to repay it, then all of a sudden FEMA can then reconsider the benefits and possibly award them to those individuals. But for both insurance and the SBA, it's that understanding that, look, there's this referral that you go back to the insurance company, that you go back to SBA, which is an effective denial initially, but if the insurance company doesn't pay, if the SBA won't give that loan, that doesn't mean you're without recourse to getting those federal benefits. One other word of wisdom to everyone before I conclude is that when you're interacting with individuals that have been impacted by a disaster, it's going to be so important for them to document everything that's transpiring, to not only document the what's happened as far as the damages to their home, to their personal property, to other things that might be related. Also, when they're starting to make repairs, keeping receipts, so keeping a record of what's happened. At this point, I'm going to turn it over to Jeff Haney to share information.
Thanks, Karen. And while Jeff gets his slides up, I forgot to mention at the beginning that if y'all have questions, you should have a chat feature in your webinar screen that you can send questions that way, or there should be a way for you to send a question directly to the organizer, and then we will, if we can fit questions in at the end, we will certainly do that. Jeff.
Thanks, Laura, and thank you, Karen, for a lot of good information. Laura, please interrupt if I've got my slides up, and I'm hoping it'll work this time where everybody's screen will track with mine. But if it's not, just let me know and I'll try something different.
Will do. So far, it seems to be working.
Okay, good. All right, hey everybody, my name is Jeff, and I'm going to talk to you about tenants' rights. Evan will talk next about homeowners and some things dealing with mortgages. First, I'm going to talk about tenants because if you're at a legal services office or doing pro bono work, you're probably working with at least some renters, and renters are definitely one of the major groups impacted with a hurricane or other natural disaster. So I've got my email here on this first slide that you can come back to if you need, because I'm happy to email this presentation to anybody individually or talk if questions come up, anything like that. All right, so one of the main things we're going to talk about, because this is always the issue, is repairs and inhabitability. Is the place still inhabitable after the storm or whatever other disaster? So here are a couple of main questions we're going to talk about. Who's obligated to repair the damage? And we are talking about residential rental property here. And how is that obligation enforced? What are the tenant's rights if part or the whole unit is rendered uninhabitable? So that's going to be kind of our main topic, and I've gone ahead and listed here all of the statutes that I'm going to refer to. I think all of them. There might be one other that I refer to later in the presentation, but it's on the slide. So just wanted to try to have that all here for you to be able to reference later. For those of you who don't do landlord-tenant work on a regular basis, a few things to know before we get into it. One, it's a pretty small world, thankfully. The Landlord-Tenant Act, the Residential Landlord-Tenant Act, is not very long. It's not super complicated. It's a pretty compact thing, not a real tough nut to crack. The other thing is there's not a lot of case law, at least binding case law at the DCA level, and that's good and bad. It's frustrating a lot of times, but so if you go to searching DCA case law and you're not finding stuff, it's not you. There's not much there. And that's part of the reason to give you all these statutes and to run through this stuff. For those of you who do landlord-tenant work on a regular basis, a lot of this is going to be some background review. But for those who don't do it often, I think the background is going to be helpful and you'll see why. Because I'm going to talk about kind of two different paradigms. One, I'm going to go through just the general rules about repairs and inhabitability, and then I'm going to get to the section of the statutes dealing specifically with casualty damage and storm-related things. And I think you'll see as we go along why I'm going to do the general rules, because you need the context, and because the statute dealing with storm damage has some things that are not clear, you need to just have it in the context of the whole Landlord-Tenant Act to be equipped with all the arguments and what the landlord may argue and so on. This discussion is going to assume a couple of things. We're talking about damage caused by a storm or something, not by the tenant's negligence. As you can imagine, the rules would be different if we're talking about something that the tenant did or some problem that developed because the tenant didn't do anything about it, didn't report it, things like that. So we're going to be talking about storm-related damage or something other than tenant's negligence. We're also talking about a structure owned by the landlord, not by the tenant. Those of you in South Florida, Central Florida have more mobile home parks than we do up here in Northeast Florida anyway. And so it's just important to remember, if you're dealing with a mobile home that's owned by the tenant, you're going to be under a different set of rules. So we're talking about Chapter 83 of the statutes where the landlord owns the property and the structure that the tenant is renting. All right, so like I said, we're going to go through the general rules. I'm going to try to go through this part pretty quickly. I don't want to bore those of you who do this often. But under the general rules, what's the deal with repair obligations and enforcing those obligations? Well, under 8351, that's the main statute governing the conditions of residential property and the maintenance. The landlord must comply with any applicable local codes. So like, for example, Jacksonville, where I am, has a really comprehensive local housing safety and maintenance code. It's a good thing because it's very protective of tenants in terms of requiring some pretty, not real high standards, but at least some basic standards that a property has to be kept to. If there are no local codes, the landlord's got to maintain some basic structural soundness that's set out in the statute itself, in subsection 1B of the statute. It's also important to know under 8351, that basic rule there, that first basic rule, can be changed in a written lease for a single family home or a duplex. The statute only says it can be changed for a single family home or duplex, so it can't be changed in a lease for something like an apartment. Now what this means is in a single family home or duplex, the lease can put as much as every repair obligation on the tenant. And so those of you who do landlord-tenant work know well that you got to find out if somebody's in a single family house, you got to see that lease because it may make them responsible for repairs during the term of the lease. And finally, under 8351, for units other than single family home or duplex, the landlord has to make some additional provisions that are laid out in subsection 2A of the statute, unless there's a lease that provides otherwise. So a good example is an apartment. An apartment complex generally has to do the extra things listed in subsection 2A of the statute. And it's things like pest extermination, providing locks and keys. It's nothing earth shaking, but it's just a few extra provisions that the landlord has to make unless otherwise provided in a lease. Okay, so those are the general rules about landlord maintaining the property. How does the tenant generally enforce those under normal situations? Again, you'll see why these general rules are important to our topic of disasters in a minute. So generally, the tenant is going to enforce the landlord's obligations under 8351, the statute we were just talking about, and the lease by one of two main options: withholding rent or terminating the lease. And I've listed here the statute that covers each. You're obviously going to want to look at the statute. If the tenant wants to withhold rent, that's covered by 8360 1B. Tenant wants to terminate the lease, that's 8356 1. And so there are different reasons to choose one or both of those options depending on the situation. But both of those options require the tenant to first give the landlord a 7-day notice that lists the things that need to be repaired and tells the landlord, hey, you've got 7 days to do these things or else I'm going to either withhold rent or terminate the lease. And pursuant to 8360, the landlord's failure to comply with 8351 or the lease regarding maintenance is an absolute defense to an eviction action for unpaid rent. So that's another way those obligations are normally enforced, is the tenant has a defense if they've given that notice, hey, landlord, fix this stuff or else. And if it goes undone, the tenant's going to have a defense if they withhold the rent, and an eviction case is filed because of that. Under 8356 1, the tenant can terminate the lease, or if the landlord is working on it, trying to get things done, it's just taking a while, the tenant has two options: either get out temporarily and no rent at all is due during that time, or stay in there and the rent is reduced in an amount proportional to the loss of rental value caused by the non-compliance. All right, you will see some similarities. Those are the general rules, and when you get into a situation, you're going to need to go back and review those. And here is the different statute that applies in our context of a hurricane or other natural disaster. And I've put the text of most of this statute, except for the last sentence, which isn't relevant here, on this slide so that you can see some of the things that I'm talking about that are a little weird and raise some questions about the statute. Says if the premises are damaged or destroyed other than by the wrongful or negligent acts of the tenant, so that the so that the enjoyment of the premises is substantially impaired, the tenant may, give me 1 second, I'm sorry. The tenant may terminate the rental agreement, immediately vacate the premises. Tenant may vacate the part of the premises rendered unusable by the casualty, in which case the tenant's liability for rent shall be reduced by the fair rental value of that part of the premises damaged or destroyed. So that looks a little bit familiar. That's like 8356, the normal rule where the tenant can, if the landlord's not getting things done right away, the tenant can either get out and not pay any rent, or the tenant can stay and pay reduced rent. So similar thing here. A couple of things to note about this. First, it's funny, casualty is not defined in this section or in the definitions section of the Landlord-Tenant Act. I mean, we know what it means, but it's a little bit strange to me that it's not defined here. It raises some questions about this statute applying in other circumstances. But anyway, casualty generally means something like disaster. I mean, you'll see reference in an insurance policy, for example, to fire, storm, or other casualty. So it's disaster, basically. So it's what we're talking about today. But it's funny that that's the title of the statute, but that term isn't even used in the actual text of the statute. But anyway, so let's talk about how this statute helps tenants. Give me 1 second here. All right. So, like I said, based on the title, it seems this was meant to apply in our situation of a hurricane or other natural disaster, either instead of or in addition to 8356, the kind of normal rules. So it's important to note why this matters, and here's why it helps to have that context of the general rules and compare it to this. You'll remember 8356, the normal rules, are tied to landlord's compliance with 8351 and the lease. And remember, under 8351, a landlord, at least in a single family home and duplex, can totally shift repair obligations to the tenant. Well, This section 8363 is not tied to 8351 or to the lease. And we'll talk a little bit more about why that's important, but there's a statute in the Landlord Tenant Act, 8347, that specifically says that the rights provided in this chapter, the Landlord Tenant Act, like these rights here in 8363, cannot be waived or precluded in a lease. So this means, and this is, I think, one of the important examples, because if you've got a client, for example, in a single family home or duplex, there may be a written lease that says, hey, all repair responsibility is on the tenant, not the landlord during the term of the lease. But under this statute, which is not tied to 8351 and under 8347, these rights can't be waived in a lease. I don't really care what the lease says, even if it's bad for the tenant generally. And so this is where this statute is very protective of tenants, I would argue, where otherwise tenants might have some trouble because their lease puts repair obligations on them. So in other words, even that tenant who normally is going to have to do all the repairs and can't do anything about it if the landlord doesn't step in to repair, if it's natural disaster or hurricane, that tenant may do what 8363 provides, which is like 8356. They can terminate the lease and leave immediately, or they can stay and pay reduced rent. So it's very important to look back at the statute when you have clients coming back to you in the situation of a hurricane or natural disaster, because this is significantly different, not because of the options it gives, but because, like I said, I don't really care what the lease says now. This statute should override, because if it doesn't, if this statute isn't meant to apply in these unique circumstances, and if these aren't some of the rights that are kind of guaranteed by 8347 and can't be waived in a lease, then this section is totally meaningless. And rules of statutory construction don't let us interpret a statute or any part of it as if it's totally meaningless. So again, this is very protective of tenants in a natural disaster, to be able to get out of a lease and get out right away and cut off their liability for more rent. All right, another question that comes up, and I've seen this come up in the context of natural disaster, is lease termination, and we're going to get to the question specifically. What comes up is what if the landlord wants to terminate? Okay, the tenant under 8363 can terminate. What about the landlord? So we're talking about lease termination. Again, normal rules, we've already covered that for the tenant. Normal rules for the landlord, they can terminate for tenant's failure to comply with 8352 or the lease. 8363 is funny because it says the tenant can terminate the lease. It doesn't say anything about the landlord. It doesn't say the landlord can terminate the lease. It doesn't say the landlord can do this or that. It only gives rights to the tenant. And I mean, I understand a landlord's argument that well, that's not fair, that can't be quite right, something's missing, or I mean, I don't know what to tell you, but that's the law. The legislature knows how to give options to both, and that's one reason I think 8363 is set apart and labeled casualty damage and is different from the others. It's only giving rights to the tenant. So what if a landlord, which is going to happen, I've seen happen, comes along and says, hey, this place is really messed up by this hurricane or whatever else. I need you to get out. This is so extensive. You got to get out of here for me to repair it. Is that allowed? Well, arguably no. It's just not a right given to the landlord under 8363 in the context of casualty damage. They've got to wait till the end of the lease or until the tenant breaches. I've put here a reference to 8344 to be aware of that statute, because it applies generally to landlords and tenants. It's in the Landlord Tenant Act, and just says that every party has an obligation of good faith in the performance and enforcement of every lease, and that just may help if you are in a situation with a landlord trying to use a disaster to get a tenant out. If a judge is confused by 8363, 8344 may help remind the judge that, okay, wait, the landlord can't use this to his or her advantage and to the tenant's disadvantage to pull something unfair to get the tenant out. I do not think the landlord can terminate the lease just because of storm damage. All right, that is, let me just make sure. Okay, the only other thing is how to terminate the lease if the tenant wants to do that. Under 8356, it's obvious the tenant has to give a 7-day notice. There's no such requirement in 8363. I think that's one of the strange things about it. It doesn't say 7-day notice, 3-day notice, any notice. But the tenant needs to give some notice. If you're advising a tenant, obviously you're going to advise them to give some notice because they need to document everything because there probably will be some dispute. So the tenant should still give some kind of notice and keep a copy just to be able to document what they've done and why. That is it for me. Initially, I was hoping to cover insurance that might come to tenants' aids. I don't think there's time to get into that. Hopefully the tenant has renter's insurance, and that's probably enough to be said there. I am going to now pass this off to Evan to talk with us about the homeowner side.
Hey everyone, Evan Rosen here. We're down in South Florida. We've litigated foreclosure cases at the trial and appellate level throughout the state. And we're going to talk a little bit about the impact of various servicer regulations and federal agency regulations on foreclosures and mortgages. So as Karen pointed out, this all starts with the presidentially declared major disaster area, PDMDA, that's listed on the FEMA website, and that's what triggers all of these agencies and servicer regulations. The servicer regulations are driven by either an agency like FEMA, which then trickles down to FHA for FHA loans, Fannie, Freddie for their loans, and so forth, VA, and we're going to go through those. Starting with FEMA, again, Karen did an awesome job covering the process of that, and it was great to hear that. What I'm going to just touch on is some of the regulatory rules that apply in the CFR. I just found, I'm just going to bring out a couple things that I thought were of interest. One, that there's a cap under this subsection here, but the cap can be adjusted. Here on subsection C, if you refuse assistance and what they consider to be an unwarranted refusal, then that could result in the forfeiture of future housing assistance. Flood insurance benefits, generally you got to have, if not, maybe not generally, maybe always is the way I read it, you have to have flood insurance to get any FEMA flood benefits. That's like a condition precedent apparently for FEMA to jump in. If you're in a flood zone, you don't buy flood insurance. From what I understand, that might be a bar to any help. CFR 20617. A lot of may language throughout this at every level. It seems mostly aspirational and very little mandatory. Even the stuff that's mandatory, I'll get to in a little bit, is somewhat illusory. So temporary assistance, alternate housing, short-term lodging expenses, direct assistance. One of the examples is this that the lodging units. The FEMA trailers that became famous during Katrina and others. Then there's either repairs, replacement, and or construction. There's a variety of conditions for those types of benefits. 20613 is a driving force along with some others, and here's 20613. a number of different eligibility factors that go into this. And I don't want to just read from these. I'll just try to pick out some that I think are interesting. Under 3, you have to agree if you have insurance, they're going to help you if there's some delay of some kind, or I believe I'd seen that it was inadequate in another provision on 4. But you have to agree that you're going to repay FEMA when you get your insurance proceeds. And let's see, this is various eligibility under sub A of that CFR written up at the top. And this is copy and pasted from the reg. There's a provision for a renter's primary residence no longer available. Then there's ineligibility after they go through when you can be eligible. It's the inverse for this sub B, and mainly if you have other accommodations is what I took from this is one of the big issues. If you left in response to official warnings as a precautionary measure, but you're able to return but don't for some reason, that's a bar. It's fairly common sense and seemingly fair as I run through this. Ineligibility, business losses, Karen touched on that. That's sub 9. That's where SBA may pick up, but generally speaking, FEMA is not for businesses. And then there's some other stuff here, some other financial assistance that Karen did touch on, medical, dental, funeral, a number of specifics that they list out in this regulation, and the ways to apply. Interestingly enough, you apply through the U.S. Small Business Administration, and then there's some other criteria. There's a very lengthy provision about how states can apply for their own grants through FEMA and then administer their own programs. That's 206-120. Then we move on to FHA, and there's a couple steps here. Whether or not, of course, you suffer damage, whether or not there's any other resources, possible options. If you're already in default, then there could be a moratorium. We have seen that pretty much in every major storm. When there's a disaster area declared, it's just like an automatic, and I'm going to touch on what seems to be the driving force of that in these storms and when there's disaster areas declared. If the disaster causes the default, then the lender may waive late fees, and there's some more that are referenced here. What I thought was interesting, I highlighted it as going through this, is that on a HUD loan in the HUD handbook for FHA loans, the foreclosure can't be initiated until at least 3 payments have been missed. And then there's one other condition regarding loss mitigation. We all are aware or should be aware of the case law on the FHA face-to-face meeting. There's been some fantastic work at the appellate level on that issue, and how it is a condition precedent. And I gave a link there to some more information about the HUD programs. Like Jeff, I'm happy to share this with anyone. If anyone wants to reach out, you can contact me. The phone number's 855-55-ROSEN, 855-55-ROSEN. And you can just, whoever answers the phone, you can just give them your email address and we'll send you the slideshow. VA. So some interesting stuff here with VA. Again, a lot of conditional language. They're encouraging servicers to do different things. And there's a variety of options for loan mods and supplemental loans that can help. They also encourage a moratorium, like we just saw in FHA. And then they talk about application of insurance proceeds. There is more also here online through the VA. Fannie Mae, this to me was where I made reference before to somewhat illusory language. So what does the servicer must do under, this is a Fannie Mae table, I think from April of this year, it was put out, that one way we have to determine if there's adequate insurance. We have to ensure that the insurance claims are filed. So you have to counsel the borrower. You have to evaluate each loan on a case-by-case basis. You have to ensure that you take specific action that doesn't jeopardize Fannie Mae's ability to get paid. You have to contact Fannie Mae. So nothing in here that says, you know, here's how you have to help a borrower. And it's aspirational. This is where you know, the thrust of things seem to be. The very first sentence here, this is copy and pasted from servicing guideline. If you think there's a problem with the property or the employment or income status, then you must suspend legal proceedings. You got to contact Fannie Mae if you're looking for more than 90 days. If the property's been destroyed, you got to stop or not initiate foreclosure proceedings. And there's some links there to the servicing guidelines and some more information on Fannie Mae. Freddie Mac, there are certain parameters in which there can be no late charges. Same thing for credit bureaus. Whoops. There's a forbearance possibility. There's an extend modification if you haven't missed. If you only missed one payment since the disaster occurred, then there's like a temporary mod. And then if it's longer than that, they have this other capitalization and extension program where you can capitalize arrears. There's an April 18 guideline and some more information on Freddie as well. What we see is that when a storm hits and the courts come back online, there's a rush for banks and servicers to suspend activity. The driving force, and I reference this in bullet point 2, this quote unquote second condition, seems to be the concern about the property. What's going on with the property? If they can confirm that there's no problems, then from what we see, there's very little, there's actually no reach out as to you know, whether or not there's options. Now, granted, our clients are already in foreclosure. It's not that the disaster caused it. So at that stage, they're reaching out to us, if at all, to ask about condition of the property on occasion, but mostly they're doing it on their own. They're seeking under a quote unquote FEMA hold that due to FEMA regulations, and you don't see them citing much, although they will cite to the disaster declaration in some of these motions to stay proceedings. But that's the thrust of it, is we want to check on the property. We don't want a sale to take place while, let's just say, worst case scenario, in a disaster area, there's no more home. We may need to process some insurance. We don't want a new owner taking over of a property that's been destroyed or that's unfit. So there are liability and financial reasons that they want to get things fixed under the current paradigm before there's a change in ownership or a change in possession. And that's all I had for the review of how foreclosures are affected by natural disasters, the different servicing regulations, and this is the CLE information for everyone to jot down. And the public interest law section has various subsections, one of which is consumer protection. And so we put in there the link to join that section as a member of the Florida Bar. And with that, I will turn it back to Laura and John.
Great. Thank you, Evan. I really appreciate it, and I appreciate everybody else's contributions here today. I just want to reiterate that this was this webinar was sponsored in conjunction with the Public Interest Law section, which is soon to be the Equal Justice section, as we go through a bit of a rebranding, and specifically by the Consumer and Tenant Protection Subcommittee. And so if you're not already a member of the public interest law section, we encourage you to join. It's only $35. It's a great group of public interest and legal aid and public defender attorneys and organizations. And a huge thank you to Legal Services of North Florida, who also helped put this webinar on. Without them, we would not have been able to offer this to you for free today. So we are greatly appreciative of their partnership in this endeavor as well. I also just wanted to quickly mention another resource when a hurricane or natural disaster hits is the Florida Attorney General's office will also take price gouging complaints. So if you have clients or you personally have experienced an increase in price for an essential commodity, which is typically food, water, gas, hotels, things like that, the Attorney General's office will activate the price gouging hotline, and there's a button on there that you can click to report an increase in the price of essential commodities. And so you can report those, and those complaints will be investigated as well. We did have a couple questions, so I'm going to try to run through these really quickly just to see if our presenters have a minute to answer these. We've got one that says, a homeowner was told by FEMA they needed a denial from their insurance company when the insurance deductible is more than the damage. The insurance payment was denied accordingly, just to be told by FEMA they did not qualify because home was already inhabitable. So apparently homeowner filed an unnecessary claim. Any suggestions? So that sounds like maybe one for Karen.
Yes, thanks, Laura. So the interplay between FEMA and the insurance claim is one in which FEMA does want individuals to go back to the insurance company to see whether or not benefits will be awarded. It's not a guarantee, though. FEMA still has its standard in determining whether or not that home is safe and or habitable. And if FEMA makes a declaration that yes, it is, then it's a possibility that you might get some insurance benefits, right? It's possible that the insurance company could pay for spoilage, food spoilage, damage to a fence outside, a tree fell on a fence, based on coverages available under that policy. But then individual comes back, says the insurance company only paid this amount or didn't pay anything, and then there might not be that award based on that standard of the home being safe.
Great.
So
and
what?
Then, one more for Jeff. Who decides what the reduced rent should be? A realtor? If the realtor says this apartment has no market value as it is with damage, then tenant can pay zero rent?
Yeah, that's a good question. That's always a tough one. There's really no concrete answer as to who determines other than a judge if it gets that far. So I always tell tenants that they need to negotiate in good faith and, present their side of it, and the landlord's going to do the same. And it's going to be like any other negotiation. They're going to start at opposite ends, and hopefully they can get to something reasonable in the middle. But that's kind of the weird thing under the statutes. There's no science to it. And I've got a case dealing with that right now, and I'm not really sure what the judge is going to do. But that's just the nature of it. That's why tenants just need to be kind of armed with the statutes and the way things go, so they can present their side in the best light.
All right, thank you. Well, I know we're out of time, and I see John has put up for us the remaining webinars in our series. We encourage you to join us for these webinars as well. They're also free and sponsored by the Public Interest Law Section and Legal Services of North Florida. So please look for registration information soon. And thank you all very much for attending, and thank you to our speakers very much for their contributions today. Everybody have a good day.
Okay.